Press the bell icon on YouTube and don't miss another update.
Cut the Clutter today goes back to the judiciary, and it focuses on a couple of important issues which are now causing confusion and I bet a bit of clutter in your minds. Essentially, I'm talking about issues arising from two things. One is habeas corpus, second, Article 21 of our Constitution. What is habeas corpus? It literally means in Latin, produce the body. Usually what it means is if somebody is missing, the person's family, friends, anybody can go to the court. It has to be a high court or a Supreme Court because it's a writ to say so and so is missing. Please let me know where the person is, if the person is detained, who's detaining him or her, and if it has been done fairly and following due process of law. This is the most fundamental responsibility of our judiciary because this pertains to an individual's life and liberty. And what is it that guarantees an Indian citizen's life and liberty? This is Article 21 of our Constitution. In many ways, Article 21 is the foundational article of our Constitution because right to liberty, right to life, right to dignity, etc., these are fundamental, foundational to a constitutional liberal democracy. Now, what are the issues that arise from these two that are cluttering our minds right now? There have been several cases, particularly after Kashmir, where people have gone to Supreme Court raising the same questions. Where am I? Where is so and so? There is the Shah Faisal case. There is also the case of Yusuf Taregami, who is the CPM's leader, the only CPM leader, I would say, outside of Bengal, Tripura, and Kerala, who can still win an election in India. And he does so very often, more often than not, in Kashmir. So he's been sick, he's been under detention. Sitaram Yechury, who heads his party, went to Supreme Court with the habeas corpus. So the Supreme Court said, all right, you can go and meet him, but when you go and meet him, they put conditions. When you go and meet him, don't do any politics and come back and do a report on your visit. Now, first of all, is that really the job of the Supreme Court? The job of the Supreme Court is to direct the state to produce the person, not physically, but to say the person is with us, and this is the law and whatever regulation under which he is being detained. But on the other hand, this completely innovative idea has been implemented. Once the Supreme Court does such a thing, others will do it. Any precedent will be repeated tomorrow, and if I may say so with great humility, a bad precedent is guaranteed to be repeated in the future, and my second law, a bad precedent is guaranteed to be made worse by those who repeat it in the future. So at the Supreme Court's level, you have to be very careful doing innovative things. But that's been done. Again, in this case, the case came up, the mention came up on the 23rd. The Chief Justice is these days busy in day-to-day hearings of the Ayodhya case. So Justice Ramana's case, the court said it should go before an appropriate bench. That took 3 days for the registrar then to list that. Why should that happen? If the Chief Justice is busy every day in the Ayodhya case, why should somebody looking for life and liberty, which is immediate, be made to wait for 3 days because somebody has to allocate it to his bench or wherever? Chief Justice is the master of the roster. Why can't the Chief Justice for this period actually lay down a different principle of the roster saying that these mentions can be made? I don't know if that can be done legally, technically, but I don't see why. And if you can set innovative precedents, then you can also set up some good innovative precedents, good in the sense that they weigh in on the side of individual liberties, not convenience of the state. Second, we've had these other references in the Supreme Court, say Anuradha Bhasin case, saying situation is very sensitive, we'll hear this a bit later. That, again, with due apologies and with great humility, is not the remit of the Supreme Court of India. It is not the remit of the judiciary. The remit of the judiciary is to apply principles of law and constitution. Judiciary does not work on the basis of running commentary from ground zero, as we say on TV channels, or on the spot reporting or aankhon dekha haal. Uh, Law and constitution and their principles don't change as circumstances change. Application of law by the Supreme Court of India cannot be Keynesian. I change my mind as facts change. You can change your mind on the facts of a case as facts change, but you cannot change your mind to the law and the constitution that exists. So that is the second argument. The third is, you see many cases in which the court is now setting new systems and new precedents, and not all of them are friendly to individual liberty. This started, say, about 10-15 years ago, but really reached its peak during the 2G and coal scam cases. 2G case in particular. 2G case was one where the Supreme Court itself ordered the trial court not to give bail to any of the accused. Now, this is a very paradoxical order that the top court in the country says these people will not get bail. Now, first of all, it is not for the top court to assess the evidence in a case or to pronounce anybody guilty. But the impact of that and then very frequent directions to the trial court almost seem to be that the Supreme Court was telling the trial court that these people are guilty. Those accused remain in jail for nearly 2 years. And then what happened? They were all acquitted. Now, who's to be responsible for people who, as of now, are completely innocent, having to spend 2 years of their life in jail and of being deprived of their life and their liberty for that period? It's not good to be in jail, to be denied your liberty. And this is not even a political prison like, say, during the freedom movement. This is a tough prison. So these are issues that the Supreme Court should be addressing now and should be debating. On the other hand, you get the impression that they are reading the newspapers and watching primetime TV too much and responding to the situation instead of interpreting the law, which is their primary job. Now, we talked about 2G case. There have been many other cases where the courts have said this will be under a court-directed or court-controlled or court-supervised investigation. The moment you see call something a court-supervised investigation, you are pretty much again signaling to the trial court that the accused are guilty. These are all wrong practices, anti-liberty practices which have come in the course of time. And I would request the courts once again to reconsider it, because the Supreme Court of India carries a bad conscience. And that is over something that happened during the emergency, which was 40 plus years ago. The ADM Jabalpur judgment. That was the case in which somebody, a man called S.S. Shukla, who was detained by ADM Assistant District Magistrate or Additional District Magistrate Jabalpur under emergency laws, preventive detention laws, went to court. The High Court said your individual liberties are suspended. It came to Supreme Court. The Supreme Court, by majority judgment, said in an emergency your fundamental rights are suspended. Barring Justice Khanna, nobody quite had the courage to challenge it. But remember, the only judge whose name now we remember, the history remembers, is Justice Khanna, who dissented there. Nobody remembers the names of any of the other judges who sided with the government in that case. But the fact is that judgment and that interpretation of the law, that state could take away your liberty and life in a national emergency, internal or external, this was internal then, that stayed as the law until last year. It is only last year in the right to privacy judgment that a 9-judge bench of the Supreme Court of India, in a unanimous order, expanded the order on right to privacy and also used it to set aside that ADM Jabalpur case. So it took them 42 years to wipe out that blot. But as I'm using Shakespeare's famous line because our higher judiciary tends to use a lot of literature in their judgments, that spot hasn't fully gone. That damn spot still remains. And that concern still remains. So it's important now that the current generation of judges at that level not do anything that makes them embarrassed in front of their grandchildren going ahead, as happened with the judges of the emergency era. That's why they have to now review what they are doing. That's why many of the things they have done lately are give us cause for a great deal of concern. And before I conclude now, I will mention something else. Just as we are talking of all these cases where habeas corpus is being put off by 3 days, 4 days, 5 days, freedom of speech cases are being put off by 2 weeks, 3 weeks because of the situation on the ground. In that situation, today the Supreme Court of India has passed an order. And this is an order that I pick up, the reporting of which I pick up from a website called Bar and Bench. I will read a para from this order. This is an order laying down the rules for parking of motor vehicles in Delhi, the capital city of India. So the court says, quickly notify the Delhi Maintenance and Management of Parking Places Rules of 2019 by September 30. Notify, week after come and tell us what happened. But there is a para from this judgment that I want to read for you. And once I finish reading it, you will know that I'm not digressing. I'm still sticking with my larger argument on liberty, habeas corpus, Article 21. So the judge is right. Golden rule is, quote unquote, love thy neighbor. Today, the social fabric of neighborhoods is being torn asunder because of fights over this most petty, their word, not mine, this most petty issue of parking vehicles. Therefore, we feel there is a need to pass a detailed order on a mundane issue, their word, mundane, not mine. Mundane issue like parking, because this may impact town planning. So far, so good. And then there's a killer para. It says, proper parking policies will also lead to less pollution, no argument, less crime, no argument, road rage now is a problem, and a better and more dignified life which every citizen is entitled to under Article 21 of our Constitution. So the same court which has the time and which has the mind space to expand the jurisdiction of Article 21 of our Constitution to rule on better parking norms in our cities is taking its time using the same article on questions of individual liberty and freedom and right to life. I think that is a worrisome thing. I hope I've been able to make it a little bit clear to you. If you have any questions, please write to me. I will answer them. And once again, please do subscribe to our YouTube channel and tell your friends and family to do so too.